And that brings to a close questions for oral answer. I call on members' order of the day.
Members' notice of motion number 1.
Charles Chauvel.
I move that the House disallow clauses 3.1, 3.2, 8.1 and 8.2 in the schedule to the Plumbers, Gas Fitters and Drain Layers Board Plumbing Registration and Licensing Notice 2010, clauses 3.1, 3.2, 3.3, 3.4, 8.1, 8.2, 8.3 and 8.4 in the schedule to the Plumbers, Gas Fitters and Drain Layers Board Gas Fitting Registration and Licensing Notice 2010, clauses 3.1, 3.2, 8.1 and 8.2 in the schedule to the Plumbers, Gas Fitters and Drain Layers Board Drain Laying Registration and Licensing Notice 2010, and clauses 6 and 7 in the schedule to the Plumbers, Gas Fitters and Drain Layers Fees Notice 2010, but that disallowance of clauses 6 and 7 in the schedule to the Plumbers, Gas Fitters and Drain Layers Board Fees Notice 2010 not take effect until 31 March 2012.
Charles Chauvel.
Mr Speaker, in March last year, the Plumbers, Gas Fitters and Drain Layers Board issued the 4 notices named in the motion that I've just moved. In May and June last year, complaints were made by members of the industry to the Regulations Review Committee about new training requirements put in place by the notices for plumbers and drain layers. Similar requirements already apply to gas fitters. The requirements will have to be fulfilled before an annual practising licence will be able to be granted. A further separate complaint was made by a member of the industry last July about the way in which the board set its disciplinary levy, the way in which the board finances the hearing of complaints against members of the industry. The standing order ground for the complaints about the continuing professional development requirements and the complaint about the disciplinary levy are that they made some unusual or unexpected use of powers conferred by the Act. An additional standing order ground was relied upon in the complaint concerning continuing professional development requirements, that the consultation requirements set out in the Act were not followed. The Regulations Review Committee agreed to hear the complaints, sir, and did so in November last year. We heard from the complainants and from representatives of the board. In respect of the 2 complaints, we upheld them. We were not satisfied in respect of the continuing professional development requirements that they had been dealt with under the relevant statutory provisions by the board in a proper fashion, nor were we satisfied with the consultation undertaken by the board. We did not feel that it was sufficiently thorough or meaningful so as to ensure that the requirements were truly relevant to the industry. In respect of the disciplinary levy, we were not satisfied that the board had a correct understanding of its statutory powers. According to the evidence that we heard, costs for collection of bad debts, a practitioner roadshow, a fees review and a debt collection project were all included in the calculation of the levy. The board also appeared to think incorrectly that it could use the levy to enforce action against non-registered persons. For those reasons, we unanimously decided to uphold the complaints, and in February this year we reported to the House drawing its attention to the 4 notices. In addition, we made a number of recommendations to the government. A response to those recommendations is due next week on the 16th of May, but it was tabled today. In it, the government accepts the committee's recommendations, and I thank the Minister for his thorough consideration of those recommendations and his acceptance of them. In accordance with the committee's usual practice, following our decision to uphold the complaints, a member of the committee placed a disallowance motion on the order paper. On this occasion, the disallowance motion appeared in the name of the Deputy Chairperson, Tim McIndoe, because of my absence on bereavement leave. Ordinarily, that would have completed the role of the committee. Standing orders provide that disallowance motions moved by members of the Regulations Review Committee must be brought on for debate by the government within 21 sitting days, or the regulations that are the subject of the motion lapse. That's the way that the committee is given teeth by standing orders. But on this occasion, the committee made an error. We were well motivated in doing so, but it was an error nonetheless. After we reported to the House in February and after the Deputy Chairperson moved his disallowance motion, the committee's involvement should have stopped. If the government had concerns about the disallowance motion, it should have brought it on for debate and then moved amendments to it, as I apprehend that Mr Williamson may shortly do. Instead, the government asked to meet with the committee to express concerns about the disallowance motion. We were told that it would put the financial viability of the board in jeopardy if it proceeded in its current form. For that reason, we agreed to meet with officials to hear the detail of the government's concerns. We took them to be principally concerned with the disciplinary levy rather than the continuing professional development requirements, and because we were concerned not to send the board insolvent, we took the unusual step of agreeing that it was desirable to defer the coming into effect of the disallowance motion. So the Deputy Chair withdrew his motion and I put one on the order paper, which is the one that we're now debating. It's identical to the original motion, except that it provides that disallowance in respect of the disciplinary levy should not take effect until next year. Regrettably, this didn't satisfy the government. We received further correspondence and heard from the Minister that his officials should also have asked for a deferral of the disallowance of the notices concerning continuing professional development. When he spoke to us on this subject, because of course we made ourselves available to him when he asked, the Minister made further criticisms of the committee's process. However, we didn't feel able to defer to the Minister's request for yet another disallowance motion, and instead we suggested that bringing the matter on for debate was the appropriate thing to do. I do commend the Minister and the Government for agreeing to this course of action, and I confirm on behalf of the opposition that if a reasonable amendment to the disallowance motion is moved by the Minister, it will be supported by members on this side of the House. Sarah, I thought it was important just to rehearse the history of this matter, and I've now done so. I do wish to make a few points in conclusion. There isn't the time to do so fully, but I do want to say this about what my colleagues on the committee and I have learnt from this exercise, both specifically in respect of this complaint and generally in terms of our future procedure. First, the complaints had merit. The complainants were justified and right to bring them, and we were right, I think, as a committee on the evidence to have upheld them. Having said that, the new board, including Chairperson Hazel Armstrong, are doing an excellent job of trying to bring in new procedures and new requirements that we hope will see the industry being governed in the future on a much better and more sound footing. On the subject matter of the complaints, continuing professional development is a good thing in the industry, and it should be supported as long as it's properly consulted on in future and put in place in reliance on the correct statutory provisions. That didn't happen in the past. We hope that the board has learnt a lesson and will do so in the future. And similar comments apply in respect of the board's disciplinary procedures. They weren't in correct reliance on the statutory procedures. We hope we've been very clear as to how in future the board can put in place a disciplinary levy that is properly assessed and properly calculated. So those are the specific matters that I wanted to draw the House's attention to in respect of the particular complaints that we heard. I do want to conclude with a couple of general observations around the procedure of the committee as far as I intend to supervise it in the time that I have left as its chair. When we hear complaints that may have an effect beyond the narrow interests of the parties, in future we're intending to advertise that fact rather than simply advise the parties themselves that we intend to hear the complaint and hear a response to it from the subject of that complaint. And obviously what this will do is it will allow other potentially affected persons or parties to take the opportunity to be heard by the committee so that we can know the full effect in future of any disallowance motion that we might be minded to move. The final lesson that I think we've learned as far as procedure is concerned is that we're not going to enter into correspondence once we've decided on a disallowance motion, even for the best of reasons, even if it is to attempt to accommodate a legitimate concern on the part of the executive. Our decisions and any resulting motions will stand, and motions, when they're made for disallowance, will simply have to be brought on for debate. At that point, they can be the subject of amendment motions from any member of the House, including a minister, so that if the government does have a concern about the way in which we've dealt with the matter, it can put an amendment forward, and in a fully transparent way, the House can deal with the issue as was intended originally by standing orders. I think if we proceed otherwise, even when we're motivated by a desire to extend and maintain courtesy to the executive, we endanger the intended transparency with which the committee should function. So, Sir, I do commend the disallowance motion to the House, and I thank the House for the time that's been allocated so that this matter can be dealt with properly.